This is Senate Judiciary, and we're taking up the miscellaneous judiciary bill first this morning, and we have with us Eric Fitzpatrick from Legislative Counsel, Dan Dickerson from the Joint Fiscal Office, and Judge Thomas Zone, the Chief Superior Judge, and you'll hear more about that as we walk through the bill. So it takes up about 40 pages of the bill, changing his title. So Eric, why don't we walk through the bill? Hopefully those 40 pages won't be all that controversial.
Sure. Senator, oh, never mind. So,
What time are we starting?
We're on live now.
Sorry.
All right.
good morning, everybody.
Good morning. I'll start over, Joe. Good morning. This is Senate Judiciary. We're taking up H729, which is introduced by the Committee on Judiciary and has to do with miscellaneous court procedures. And Eric is going to do a walkthrough of the bill and roughly 40 pages, but about one half of the pages of the bill have to do with changing the title for the Chief Superior Judge.
Oh, I just speak. I don't need to unmute. Thanks. It's complicated.
What was bill number?
So good morning, everybody. This is Eric Fitzpatrick with the Office of Legislative Counsel. The bill number I'm walking through this morning is just recently was assigned a number because it's a committee bill from the House Judiciary Committee. And so the version that Peggy just posted on the webpage has the number. It's H729. Send the updated version. The version that you have a hard copy of may not be the version that is H729 because a couple of sections were added at the end. So when we get to that, let me know if, as I continue to walk through, let me know if I'm covering a section that you don't have in front of you. And I believe the new sections are at the end, so it shouldn't be anything that happens between now and then.
Okay.
Does that make sense?
Yes.
Yep.
Is that different than the version that was voted out of House Judiciary, recommended out?
No.
That's what they have.
Oh, okay, gotcha. Oh, maybe we'll be the same.
It should be the
We'll
same.
cross our fingers. Senators, do you want me to share the screen? Do you just want to do a walkthrough with?
I think we can do a walkthrough. I think it's up to Senator Bruce. Do you have a copy of the bill?
I have a copy of the bill.
Okay, I think we can just do a walkthrough, Eric. It's easier than sharing the screen.
Sure. Sounds good. So that's what we'll do then. So it is the annual miscellaneous bill, which I'm sure everyone knows and is familiar with. It's each year the miscellaneous bill is done by a number of committees, education, motor vehicles, tax, etc. And this is the annual judiciary miscellaneous bill, which deals with a variety of minor amendments, sometimes technical amendments that are viewed as appropriate to be in a miscellaneous bill rather than having their own bill. This year, it started in the House. Next year, it will start in the Senate. So it's going to rotate each year where the bill begins. So this is the version that, although it has passed out of House Judiciary, it has not passed the full body yet. It's on the floor today, on the calendar for today anyway. It's second to last on the calendar, so I don't know if they'll get to it, but it's on the calendar. So as is always the case with the miscellaneous bill, there's a variety of different topics that are covered. It's not any one single topic. So I will do a walkthrough that sort of tries to explain what each of the different provisions are. So sections 1 and 2 actually go together. They are purely technical changes. They were actually noted and to me by former Vermont Law School Dean Kinvin Roth, who in the course of the judicial rules process noted a couple of incorrect cross-references in statute. So that's all these are, is technical changes to incorrect cross-references. These statutes refer to a court rule that has been repealed and it's been replaced with a new rule. So since the rule is repealed, it's no Rule 78B is repealed. Obviously, you can't have a statute referring to it anymore. So the cross-references to the new rule that now covers the same topic. So that's sections 1 and 2. Section 3, now this has to do with the process. This has to do with relief from abuse proceedings, RFAs. And you may remember a few years ago in 2018, the legislature enacted Act 110. And what Act 110 did a number of things, but one of the things that it did was it created a procedure for temporary relief from abuse orders to be obtained after court hours. In other words, it could be during the evenings on weekdays, or it could be on the weekends, but sometime during non-business hours. It created this procedure because when an emergency relief from abuse order could be obtained by a victim of abuse. One of the features of that was that, because ordinarily when you apply for a relief from abuse order, you have to submit an affidavit that has to be notarized in person with the notary public. It requires in-person notarization. But that language permitted an over-the-telephone affirmation to take the place of an in-person notarization. Because they were doing it after court hours, the idea was that you wouldn't have to go through all the formalities of the procedure of going down to court, going down to the courthouse, or otherwise being in person with a notary. So that was passed in 2018. As I say, it applied to after court hours proceedings. What this proposal does is it takes that same option, the option of notarizing the affirmation or affidavit over the telephone with someone designated by the court to receive, to provide those affirmations, and applies it during regular court hours as well. So in other words, if someone's applying for an emergency relief from abuse order, and they would prefer to do it over the telephone and have their affidavit affirmed by the court staff person over the phone rather than going to the courthouse and doing it, this provides that option. It should note it's only an option. It's not a requirement. If the person would prefer to go to court in person and still do the have the affidavit notarized and have the oath given in person, they can still do that. This just permits the over the telephone affirmation process to be used during
Eric?
court as well.
Eric?
Yes.
So I think of this only because of discussions we've had about voting via Zoom, and you know, the final thought was that we had to be on camera in order to vote to make sure that we are who we say we are. So in this case, if you use the telephone, does the declaration against perjury, if I was pretending to be someone I was not, would I be guilty of that perjury and subject to that penalty?
Yes, I think the false statement statute, the criminal statute, would apply to you just as much as it would be if you were doing it in person. Yeah.
Okay, great, thank you.
Yep.
I have a question too. With
Yep.
regard to, it says, to a person authorized to administer oath, so that would be any notary public, or is this talking about a specific person assigned by the court?
I think it's the latter.
It's any notary, it's any person authorized to take oath.
Yes, Judge Zonay might know this better than me, but my understanding is that the court designates people to do these affirmations over the telephone. And up until now, it's only been during non-business hours. This would permit it to be happening during business hours, but I think there's a designee at the court who does that.
Could we find out about that? If so, we should change this, because otherwise I think people will just say it's a person authorized to administer oaths. Judge Zonay, can you weigh in on that, please?
Yes, the way that, I'm sorry, Tom Zonay, Chief Superior Judge, which again, that title takes up quite a bit of your day today, apparently. The way it works now is that when someone is calling for relief from abuse after hours, he or she will have contact with an individual. We have a number of people around the state who are designated to work through the process. Each of those individuals are notaries who are able to administer the oath, which does subject the individual taking the oath to a penalty if they are lying or if it's found out that they're not who they say they are. During this change seeks to have that same process take place during the daytime. During the daytime, at the courts, there will not be generally a specific individual designated as there are at nighttime, but rather we have any of the court clerks, who I believe are all notaries, who would be able to administer that oath and assist the individual seeking relief. And so the language as it currently is there,
Yeah, I think what Senator Nick.
Yeah.
I think Senator Nicker, and I agree with her. I think it should be clearer who can administer the oath. If it's not clear in some other place in statute that we're not seeing here.
I don't believe it's identified any further. This language was taken from the language, I believe, when this was changed for the after hours a couple of years ago. And so the intent here, this, as a practical matter, the only person who can administer the oath for this document is the court employee.
Okay.
Okay, so how about if we add by a person authorized by the court to administer oaths? So it isn't just any notary, which that's what the notary stuff reads like, you know, somebody who's authorized to administer oaths.
The difference is this section also applies to individuals who may come into court with their paperwork in hand already filled out. That paperwork under the law can be notarized before any notary. And so this section takes into account both of those circumstances. Again, the latter is something that happens now. Someone can go to the notary at the town clerk's office and have their affidavit sworn and walk it over across to the court. This language says it can also be done over the telephone by a person who is able to do it. But I see what you're saying, because this would, as you say, Senator, and point out, this would theoretically allow the person to call the person at the town clerk. However, because it's after hours, the entire process is done by the court employee. In other words, even the complaint itself is typed out by the court employee, and the affidavit is typed out by the court employee. So if it's done telephonically, the way the system works, they could not go to the town clerk to have it sworn telephonically because they are doing the application over the phone.
I see what you're saying, but
But it can be clearer. It could say, which may be sworn to or formed by administration of the oath over the telephone by an individual, by a judiciary employee, by an individual representing the judiciary, something like that could be added there. This language, I believe, was the language from Sarah Robinson of the Domestic Violence Network. And so she may wish to weigh in on that, but I would not have a problem if you wanted to clarify it a little bit and add in there in that section about judiciary employee. I think it would address that potential concern.
Why don't we go along and ask Sarah to join us next week?
okay.
Can I ask a question?
Yep.
Eric, does this language mirror the oath that appears in the document a person would be filling out at the courthouse?
Which document?
The oath that we are putting in here, does it mirror the oath that appears on the paperwork that a person fills out at the courthouse?
I don't know.
Judge Zone, would you happen to know? I'm just curious as to whether or not there's differences between the two.
I believe that the intent of this language was, my recollection is that that was a point that Ms. Robinson wanted to say in the same. And I think that there were changes to make sure it was the same. If you look at 1104, Title 15, 1104E, it says making false statements in this affidavit is a crime subject to a term of imprisonment or a fine or both, as provided by 13 VSA 2904. This oath seems to be a bit different. So I think that was something she was looking at. So I would ask Ms. Robinson about that also.
Yeah, I would prefer to see them mirror each other to the extent possible. I don't know why there would be differences between the two.
Okay.
And I concur with you. We have no issue with that.
All right. Let's move to section 4.
Section 4, just jotting something down here. Actually, sections 4, 5, and 5A are all connected in the sense that they're all related to proceedings for sealing criminal history records. And these sections are also contained in the House Sealing Criminal History Records Bill, which I don't know if this committee has taken up yet, but they appear in both places, just so you know, these particular provisions. So the first one, section 4, has to do, this deals with the issue of what happens when a court issues a sealing order in order to seal criminal history records. Under current law, there's a list. You'll see it right there in statute in section 4, section 7607 of Title 13 in current law. This contains a list of which entities must be provided notice of the sealing order. So what this section does is it just adds one entity to that list. So you see, if you're looking on the version with numbered lines, say lines starting in line 16 to line 19, you see the existing entities that get notice of the sealing order are DCIC, the Crime Information Center, the arresting agency, any other entity that may have a record related to the order. And this adds the restitution unit of the Center for Crime Victim Services to the list of entities that get notice of the order. When the unit is, as we know, the state entity that's charged with collecting restitution if it's been ordered in a given case. So this way they'll have notice of the sealing.
Okay.
Section 5 makes it a civil offense. And pausing for a moment, Senator White's coming in.
I was in host institutions defending our midpoint.
Yes, they wanted me in there at the same time. I said I was already scheduled for here.
Just so you know, we're live.
I figured you were. I wasn't gonna say anything. I've almost learned to keep my mouth shut. Not quite.
So, Mr. Chair,
Yes,
I just wanted to register what might be obvious. This is the same language we discussed in the sealing bill, and so I have the same objections that it is limited to in the course of someone's official duties and limited to disclosure rather than accessing. So I assume this will be part of our ongoing discussion about sealing.
Yep.
So.
if we keep this section in this bill, then we need to have it mirror whatever we do on sealing. I would agree. And I share that concern that in the course of their official duties, so I'm out having drinks and I start talking about some kid that was at 204 Depot 20 years ago and provide his name and rank and serial number. That wasn't part of my official duty, so I'm not guilty of doing it. Is that what this is saying?
Yeah, that's a good point, Senator Sears. I think that arguably wouldn't be covered by this. So that's a good catch that you might want to revise that or strike that language.
Yeah, I think it is of concern. On the other hand, there have been times when I've had kids in here who I used to have, they're not kids anymore, who have freely given their own information out. And that's certainly their right.
But
I want to make sure that we haven't don't make it a crime for the youth to provide that information.
Yeah. And you know, to go back to the idea, if we move to sealing as opposed to expungement, I think the person who has their record sealed should have a right not only to know that they're not going to be disclosed, but that, for instance, law enforcement won't be accessing them, even if they never tell anybody what they discovered. It might still affect their mindset or their willingness to prosecute or any of those other decisions. So for me, it's not about disclosure completely, but also access to the information.
At any rate, I think it should read, you know, shouldn't just be official duties.
May I make a comment, Senator Sears?
Yep.
I apologize, and I want to make a comment first, and then I'm going to relate my another comment to the. I was looking at the screen here, and I said, "Who is that handsome guy sitting in the window there. It turns out it's Eric. I can see him both here and there. So.
Thank you very much.
So the question of if you disclose information in your official capacity, I think that it's backwards. If it's information that you gained as part of your official capacity, you should not disclose that information at all, period. I mean, it's the same in the code of ethics that we just passed. If you gained information, sensitive information or any information only because of your role as a government employee, you should not be using that information in any way for your personal gain or anything else. And I think here it isn't so much whether you're disclosing it in your official capacity, but if you gained it as in your official capacity, you should never be disclosing it, period. I don't know if
I think
that
you're
makes
in
any.
agreement with Senator Baruth and myself then.
Okay,
So say we're here at the State House in our official duties, and a person comes charging into the Judiciary Committee threatening us. Is that covered also, that I can't tell somebody about that when I see the guy in another place?
no,
All right.
because you didn't gain classify any important knowledge that everybody else couldn't have gained at the same time.
And we're talking about stuff that has been sealed. So that wouldn't
Here.
have
Oh,
been
that's right.
adjudicated.
Oh, that's right. That's
Yeah,
right.
here, yeah.
That's right. I'll say he had his record sealed after he did it. All right.
Judge Zone has a comment.
Is it, during the walkthrough, Senator, is it okay if I do pipe up? There's something-
Absolutely. Yeah, sure.
It seems to me that you might be able to address this if you took the language on line 5 on page 4 that says, it says, including an attorney and an employee or contractor of the attorney, if you said who, and then jump to knowingly discloses sealed criminal history record information, and then you bring back, it says obtained in the course of their official duties.
Yeah,
Or if you could either put it there, or actually it might go better after the word without authorization, but add that clause obtained in the course of their official duties, just drop that down a little bit. And I think that addresses the concern.
I
Well,
do too.
It doesn't
I think
address
so.
all of my concerns, because
Okay.
I'm concerned not only that somebody might disclose something in the course of their official duties, but that they might unofficially access for reasons of their own. So let's say that a law enforcement officer knows someone who wants information about another person, and they say, oh, I can get that information for you. And they go into the system. They're operating outside their official duties, but they're accessing the information improperly. So
The language
That's
that I
been against the
suggested,
law
I think-
for years.
I
What's
think the
that?
language I suggested would cover that, Senator, where it would
Oh.
say knowingly discloses sealed criminal history record information without authorization, comma, obtained during the course of their official duties. I do see what you're saying, because you're saying it's not an official duty when they're going on frolic and detour to get it.
right.
I believe that
Let me,
actually,
I believe that's already against, I believe that's already against the law elsewhere, though. We've had, I can remember about 30 years ago, police chief in Bennington was also a private investigator, and he was accessing information that he couldn't have gotten as a private investigator in his job as police chief, and got caught in that, and obviously was dismissed. But I believe that's already against the law, but we should check on it to make sure.
I was actually co-counsel for that individual back before Judge Ellison. It was Mr. Barton.
Oh my God. That does take us back, doesn't it?
Well,
The
just
only thing I
wanna
would
get
add
to-
here, Senator Sears, is that you may not need the official duties phraseology at all here, because I think if you look at what this particular offense is trying to get at, it's knowingly. So in other words, you know what you're doing. You knowingly disclosing without authorization sealed criminal history records. I don't think the concern is how you obtained it. It doesn't matter whether you had it for your official duties or not. It's that you knew that it was sealed.
Right.
And you didn't have authorization and you disclosed.
Yeah.
Well,
Well,
I think that's the nexus of the offense.
Well,
Yeah.
and I don't want to draw it out too much. I'm just flagging. There's also the issue of whether somebody accesses it but doesn't disclose. So they're making a roadside stop. Somehow they can get access. They don't disclose to anybody, but it changes how they interact with that member of the public. And that violates the right of the person whose information is sealed. So I know we're walking through, I'm just flagging it for later discussion in both the sealing bill and this bill.
well, yeah, and I'm not sure why this is here and not in there. But
Do we already have a law that prevents unauthorized access?
I believe so.
If we do, then it's a moot point.
Why don't we research this for both? The problem is that Michelle's doing the sealing, Eric's doing this bill, and hopefully they can also make sure that whatever we do is the same in both bills.
Yes, we can send it to you, definitely.
Okay, moving right along. We're at
Yes.
section 5A. I guess that's
Yes.
the same issue.
Yes, it's just a technical necessity because section 5 adds a civil offense, which is, as we know, brought in the Judicial Bureau. Whenever you add a civil offense to the law, you have to amend the jurisdiction of the Judicial Bureau to encompass the new offense. So you'll see that's what's done in section 5A. It's just made it clear that the Judicial Bureau does have jurisdiction of, and then you look at the language in lines 15 to 16 of page 4, violations of 13 VSA 7611, which if you look above, that's the proposed statute that's created in section 5, relating to the unauthorized disclosure of sealed criminal history record information. So it's just as I say, a technical requirement that you have to make sure that the Judicial Bureau is given jurisdiction when you create a new civil offense. So that's section 5A, sorry.
Section 6, is that Dan Dickerson? I don't want Dan here all day. This is just his own
Yes.
section right now.
Yeah, this is the section that Dan worked on as well. I'll just give you a minute of where it comes from, and then Dan can talk about some of the other financial details. And that's that this is the fee that's charged under current law. Actually, backing up a second, there are fees charged under current law for various court actions, whether it's initiating a lawsuit or this particular section having to do with fees that are specifically related to post-judgment motions. In other words, motions that are filed after judgment in the case has already occurred. Now, that fee is generally $90. That's how much it is. However, there was an exception added to that, so generally speaking, the rule is the filing fee does not apply to motions to seal. Okay, that's the general rule. If it's a motion to seal, which is a post-judgment motion, right? If you think about it, that's after the judgment. Later on, somebody files a motion to seal the records. So since that's a post-judgment motion, it would ordinarily be covered by this $90 fee. But exception created says the filing fee doesn't apply to motions to seal. So it's going to allow people to file their motion to seal without having to pay the fee. There was an exception created to that exception that said it does apply for DUI motions to seal. So if you file a motion to seal your DUI record, that's line 9. That's existing law. You do have to pay the $90. So what's been happening in practice is that that $90 fee was being charged to motions to seal not only to adult DUIs, but to juvenile DUIs. And I think there was some thought that that was not the original intent of the legislature, that they only wanted the fee to apply to adult DUIs, not juvenile. So the Chief Superior Judge, the Office of the Attorney General's Office, and Vermont Legal Aid got together and worked on this language to make clear that the fee doesn't apply to juvenile DUI motions to seal. Although it will still apply to adults. So that's the gist of it.
I had no idea. Why did we pick out DUI as the only one where you have to pay to seal?
An interesting, I've wondered that myself, and I don't know the answer.
Seems a little silly.
Judge Zone,
I would just add that not only did the enactment that was previously done to exempt the Title 13 sealings from a fee say that they had, the DWI was the only one, but that enactment actually did not include any reference to the juvenile, we'll call it, sealing under Title 33, 5119. In other words, under the plain language of this statute, if you look earlier in the section, it talks about all motions. What actually happened was the Title 13 sealings became free except for DWIs, and the Title 33 ones all still required a $90 fee. DWIs, simple assaults, disorderly, everyone. And so when that was noted, that was the impetus that we really had, and that was, wait a minute, the language here says that the juvenile cases, they actually have to pay and the adults don't. And that seemed to be something that most likely did not go with the intent of the legislature to make the juvenile 5119s all have to pay.
okay. Dan, what is the impact of this, if any?
Good morning, everyone. Dan Dickerson, Joint Fiscal. I reached out to Greg Mosley over at Judiciary. I sort of got a sense that this is more clarifying in nature, and that, in practice, this fee probably wasn't being charged. He seemed to think that was the case, and he also speculated he couldn't go into his, if you look at the total fee collections for this $90 fee, he couldn't go pick out the ones, or he couldn't easily go in and pick out the ones that are specifically dealing with these 33 VSA sealing requests. But his speculation was that, creating this very specific exemption probably would be very small as far as the fiscal impact. And so in my fiscal note, I've estimated that this would be a negligible impact.
Thank you. Any questions for Dan, Eric, or the judge? Judge Zone has a question or a comment.
According to Director of Trial Court Operations, this fee has not previously been charged, as Mr. Dickerson indicated. The issue arose, you may have heard, we had a central review program put together, and central reviewers were highlighting this. According to Lori Canty, our history was that we were not charging this fee in the past. So as Mr. Dickerson points out, it really is more clarifying.
Okay. Let me ask another question that may be more, a delinquent act's a delinquent act, whether it's DUI or stealing a candy bar or a murder, right? Under the law.
Correct.
So if the person's charged as delinquent, is there a confusion on the DUI? That's a civil, because if a juvenile commits a DUI, then it goes through motor vehicles. Would that still, is it clear that the juvenile don't have to pay to seal that?
The language as put in here exempts all of the 5119 juvenile sealings, so
Okay.
they don't pay for the DWIs anyway.
Okay, thank you.
Should we move to the next section?
Well, I'm just gonna ask Dan if there's anything else in the bill that, when we get back to the sheriff fees, we'll probably ask you back in for a fiscal note on that and any other information. But I'm curious if there's anything else in the current bill that we're gonna be going through. I just don't want to have you sitting here unless you'd like to.
I appreciate that. The only other area of the bill that I was going to point out, although this is also a very small impact, is in section 32, where the sunset of the Vermont Sentencing Commission is extended.
Okay.
The only thing this means is that people will get per diems and expenses for another year, but I think within the legislative budget for the 2 legislative members, this is going to be pretty small, and I think we can absorb it. And my guess was they could, on the other end within the judiciary, they could absorb the cost for I think there were only 1 or 2 public members that weren't state employees. So I had this as a negligible impact as well. But that was the only other item. Once I see the language for the sheriff's fees, then I'll certainly do some legwork and
If they can,
come back.
then we won't have a problem with payment, will we?
I'm sorry, you cut out.
We've been doing the sentencing commission, I believe, by Zoom in a recent, and if it continued by Zoom, I suppose there's a remote that you still would get paid, but you wouldn't have any expenses, the legislative members, I mean.
Yes, you would get your daily salary, but we wouldn't have to pay the mileage and other things. So it would be a reduced cost anyways. But in any case, I believe that we can absorb that cost within the legislative budget.
Judge, are you still the judiciary representative?
I'm,
You're still the chair.
I am, yes, and we have been meeting remotely, and I can continue to do that if it's going to help on the fiscal side.
Well, it helps on the fiscal side, but also helps me to be able to attend.
It really, that was actually a discussion we had on some other committees. I think it really has enabled people from all over the state to participate more fully. And so I think Mr. Valerio has indicated his view that we should continue to meet remotely, even if we could get back together. So that's the way it looks.
Okay, good. Good to know. All right. Thanks, Dan. Unless there's any other questions for Dan, we'll let him go back to his other duties. Thanks for joining us this morning. Appreciate it.
Thank you all.
And we'll see you when we again and talk about the sheriff's fees. Okay, Eric, do you want to? This is a really controversial subject here. The next sections. I'm not
Yes, I
sure
think
we
it's-
should do. I mean, just because Judge Grierson retires, now we got to change the name.
Yeah, I think there's been a lot of pushback on these sections. Definitely, there's been a lot of controversy, as you mentioned, Senator.
I think there should be. I mean, a judge is a judge. I mean, I don't get a title of chief senator.
Wait, you are the ranking member.
I am the ranking member of appropriation. You, Senator Bruce, for remembering that.
I think
I have,
ranking member is very weird title.
Well, that was Kitty told you when we were introducing us as members of the conference committee, and I introduced myself as the ranking member of Senate Appropriations. Because that's basically a House thing.
if I could say something.
Yes.
As I said before the House, I didn't feel comfortable coming in going, hi, I'm the new Judge Grierson, and we're going to change my name and all the statutes. And this was actually changed back in about 2014 or 15. The Supreme Court in its administrative directives and its other orders began to utilize the term. It was when Judge Grierson came on. It went from administrative judge to chief superior judge. And slowly but surely things were starting to go to be changed to be consistent. And so it was noted that we may want to take this opportunity to make it consistent through all the statutes. It did not, please understand, it was not something that I came on and went, well, we're going to change the name. It happened 7 years ago.
I know. I've been kind of joking with you, Judge, but yes, it started, I think, when Judge Grierson started and took over for Judge Davenport, I believe, when the Supreme Court changed the title.
I was going to come up with a new title for next year when the bill is before the Senate for the miscellaneous. So I'll work on something for a new title.
Okay, why don't you do that, Judge?
A little more politically correct.
So
Well,
that takes us,
I think everyone understands that from this discussion, what these sections do.
yeah,
This is section 7 through 30, make the change that Judge Zonia was just referring to, which is that since the court has changed the title of the administrative judge to the chief superior judge, these are just conforming statutory changes to, we did a search and identified any place in statute that the term administrative judge appeared, and changed it to the now proper and correct title, which is chief. And that is section 7 through 30. That takes you a good chunk of the way through the bill to section 31.
are there any
This
questions
section- does everyone
about
have
those
section 31?
sections? Section 31 is in the bill. Correct. Yeah,
Okay,
I've got that. We've got that in
so
our,
this, sorry, go ahead.
I've already moved.
So this
to-
section is, oh, okay, good. So this is a report in section 31 that's required from the chief superior judge, and it has to do with practices for collecting racial demographic data in civil court filings. And the reason that it's specific to civil court filings is that it came up during the discussion of a bill that I think is in committee or is coming to committee shortly, the Division Statistics Bill that's being that is established in a separate House Bill H546, and that requires this newly created Division of Racial Justice Statistics to collect racial demographic data for criminal court proceedings. So
Right.
in the context of that, it came up at committee. Well, wouldn't there be similar data that should be collected for civil court proceedings? There was a discussion about that. I don't think it was necessarily clear whether such data existed or how it would be collected. So the conclusion was that there would be a report back in December from the chief superior judge to talk about some of those issues, to establish or discuss whether there is collecting data currently under Vermont court proceedings, or whether they exist in other court proceedings, especially eviction and debt collection proceedings, and essentially let's say a report on whether those data are collected in civil proceedings and how it's done. And that's the proposal in section 31.
Should we compare that with the other bill? When we take that up?
Yeah, I think you're right. When you take it up, you can think about it. It's
Did you do the other bill or did another?
yes. No, I did do the other one. Yes.
Okay, so when we take that up, we may move that to make it clearer. I suppose we could move this to that. Or move that bill to this. I mean,
Absolutely. Yep. Any one of those options you could certainly do if you felt that it worked better.
yeah, I tend to think sometimes it's easier. If things are all in one place and you're discussing something.
Right. Section 32 was already mentioned earlier by Dan. This is the extension of the Sentencing Commission sunset. Right now, it's scheduled to sunset in this year, July 1st, 2022. This gives them another year to continue to do their work. So it extends the sunset until July 1st, 2023.
Is there some specific work that we're doing?
I think what the Judiciary Committee was thinking about was the classification system, the classification of crimes that is in two other bills that are coming over to the Senate. Or in fact, I think Peggy said one of them got referred yesterday, the criminal classification bill.
Okay,
So yes, I think it's that work. There may be other work as well, but that's the one at least that I've heard discussed.
okay.
Can I ask a question on
Sure.
some peculiar little thing here? So in the last full paragraph, starting on line 10, where it goes to line 13, where it says repeal of automated license plate recognition system standards. Are some municipal departments still using license plate readers?
my understanding, I asked Anthea about this, who is our counsel who works on motor vehicles issues, is that it is rare, but not unused. So they're not used much anymore, but they are used a little bit, was her understanding.
So is this taking away the standards for places that do still use them as well?
No, it's a funny, the language art, yes, if this bill, if sunset were allowed to occur, then it would take away those standards. So that's why the sunset is extended, to keep those standards in place.
Okay, good, okay.
And that's, thank you for the segue, Senator, because that's perfect. It segues me right into section 33, which does exactly that. The existing law establishes standards for the collection and storage of the data collected through these license plate recognition systems. But those standards are supposed to sunset again this year, July 1st of this year. So if they were to sunset, then as you said, there would no longer be any standards for the collection and retention of data. So in order to keep the standards in place, the proposal is to extend the sunset by 2 years to July 1st, 2024. And the last time the sunset was extended, it was also by 2 years, from 2020 to 2022. So they just kept the same 2-year window that you used last time.
Thanks.
Okay.
Yeah. And the bill takes effect on passage, and I think that covers all the sections.
Okay, and you said there's sections were added in the House?
No, they were, I guess they were, but evidently they're all in your document already. So nothing beyond that.
Okay. So I think that's a good segue to ask if there's any other questions before we take our break and go to a different bill at 10:15. We're gonna take up the civil, excuse me. What are we doing at 10? Oh, yeah, adoptions at 10:30.
Yeah.
So we were gonna break at 10:15, but we're a little ahead of time, so maybe we'll get a longer break. Would anybody object to that?
No.
Okay.
I don't think there's anything else on this bill right now. We do want to hear from Sarah Robinson, and we could schedule markup next Tuesday, Peggy. So Dan Dickerson on the fee and Mark Anderson. But I don't want to vote it out till much later in the session, simply because it's a miscellaneous bill and there may be other issues that come up.
Senator Sears, was there, I'm recollecting, I'm not remembering the exact specifics of it, but Mike O'Grady in our office indicated to me that there might be another piece you might want to add to the miscellaneous bill, and I can't remember what it was.
I don't
It was
either.
the
I think there may be
The farm?
there may be an issue that I want to discuss, but I have to do some research on it. And maybe government operations would want to take a look at it as well. It has to do with police commissions.
Police commissions?
Yeah.
Police commission?
Police commissions?
Yes. Their ability to look at different, I'll get into it. Let me do some research on it. That may be another amendment. But anyway, I plan to try to mark up at least the 23 pages in front of us. And the other thing, but I don't want to vote it out until later in the month or even into the beginning of April to make sure there aren't other issues that are identified either in House Judiciary or Senate Judiciary that need to be taken up. That's been the general practice on the miscellaneous bill. Judge Zoney may stumble across something or somebody else may as well. Okay, well, why don't we take a break